done the search to adjudicate the matter. My lord, a leave was granted to mention if the necessity arises. Now they have passed an order. My lord, I have challenged the section on which the order was passed. My lord, according to the petition, it should be passed under
Section on which means virus.
no, my lord. The section they have issued a notice under 74 of GST Act. My lord, the contention is I was unregistered.
It should not be under 74.
It should be under
73.
63, my lord, not 73. 63 because I am an unregistered party. Now they have passed an order and then initiating recovery.
Give your grounds of urgency.
So only about the small correction of the lordship's order.
Correction.
Correction. Well, group 2 when lordship was sitting in the.
What is the mistake here?
No, only instead of lordship bespoke, it will be south bespoke.
My lord, I have intimated the other side also.
Please intimate the other side because
yes.
My lord, first time the state motion unauthorized construction on the government land. Authority no step taken.
Please give it. It will appear.
Lordship, will it be Lordship's pleasure to indicate when applications will be taken up, my lord?
I'll be indicating it from next week onwards. I'll indicate in the list.
Mention that this one, the PST registration is already cancelled. The person is not able to participate in the data.
Give it. Please give it.
Your Lordship, ma'am.
Yes.
Your Lordship, in the daily list, item number 202 and item number 209 serving in the daily list. Your Lordship, the urgency is that the petitioner is getting oral threats from the department that either you give us a statement.
What is the matter about?
It's matter about, Your Lordship, we have challenged the appeal order and
Appellate order.
Yes, appellate order.
1997 show cause notice under FERA. My lord, we could never cross the stage of, my lord, responding, my lord, by receiving all the documents with the show cause notice. After 30 years, my lord, suddenly the matter has been resurrected. 5th January, they kept a hearing. We got the notice after that. They've kept the hearing today. I don't think, my lord, if I should pray for a hearing today. But if your lordship, my lord, gives me some precedence or maybe Monday or Tuesday.
File it today, you give the number, it will appear on Monday.
Great. With some precedence, my lord.
Yes, you give it. Give the grounds of urgency. Ensure the presence of other side because
yes,
party I will not. You ensure presence.
No, I totally appreciate. Yes. I don't want an ex-party order.
You give it, it will appear as an urgent motion.
Grateful.
Your lordship, extension of interim order.
Please mention the grounds of urgency so that I don't forget because I don't have the number. I'll get it. I'll see the slip and I'll.
Yes, I'll write
then
it
I'll
myself.
call it. Thank you.
Extension of interim order.
Yes, please do.
My lord, may I mention item number 463? It is a petition application. The respondent authorities have not released for the matured amount along with interest of 43 National Savings Scheme certificates for my petition for the petitioner. Kindly upgrade this matter as urgently as possible due to the
savings scheme certificate
for National Savings Scheme certificates.
It's a group 4 matter.
Yes.
It's a group 4 matter.
Group 7 matter.
Group 7 matter, I will not have determination matter. ওটা উপরে টু বি মেনশনডে তুলে দিন যদি ডিটারমিনেশন না থাকে রিলিজ করে দেব ফালতু
463
463 or 63
463
463 এর ফাইলটা একটু বের করে দেখে নিন না যদি না থাকে আজকে এক্ষুনি তাহলে ছেড়ে দেব না ফালতু রেখে লাভ নেই উনি তাহলে মেনশন করতে পারবেন অন্য জায়গায় একটু বের করে দেখে ম্যাডাম ইউ প্লিজ কাম এন্ড চেক এট around 2 PM.
Grateful.
Mentioning for upgradation, my GST registration has been cancelled. And I have no and several
cancel.
My lord, I'm mentioning one matter for inclusion in the list. The matter which
inclusion, please give, don't mention. Yes.
My lord, this I am mentioning this matter for inclusion in the list.
Give it. Call Kurun, call.
My lord, lordship's last
I'll
one.
just
Only one thing, my lord. Kindly see your lordship last order. My lord, this interim order is continuing since 2020, And Lordship has,
Till the end of.
my lord, wait, because many holidays are coming, my lord, very
Not a
tight.
problem. It will be a. I'll
Very
sign
short
it-
exchange,
I'll
have to-
sign it today.
Yes.
I will sign it today. It will be assigned by tomorrow. It's done within a day nowadays.
Oh, within-
Yes, yes.
Because very tight schedule, my lord.
No, not a problem. You still have time.
So, holiday mood, no, so a lot of holidays are coming. I was
Not a, won't be a problem. এটা দিয়ে দেবেন, আমি সই করে দেব। 2 লাইনের অর্ডার তো।
থেকে বলতে হবে আমার যেখানে আমি আসেন জাজমেন্টে হতে হবে। So, well, I more or less made my submissions. I'll just very briefly summarize and distinguish my learned friend's judgment. That is what is left for us. Institutional bias. So, one of the 3 points which I had mainly argued in answer to their point. One, first is one of the.
I'll indicate what I have understood. So that will make things.
Yes, then I will not recapitulate
Yes.
also.
One was that the DM is actually acting in a dual capacity.
Yes.
Therefore, it's not a question of DM being interested party, because in terms of the scheme and the act, he is supposed to, or whatever the
He is the
agreement
representative
was.
of the owner
Yes.
of the public land.
Yes, no, that is the second limb. The first limb is that in terms of the scheme, he is supposed to be a part of that committee. So therefore, he is the person from whom the complaint should arise, and therefore he has made the complaint.
He is the chief executive officer of the Jilla
Yes,
Parishad.
yes, that was the
Yes,
argument,
that was
and therefore he has made the complaint. And in any case, according to the law, as you have interpreted, appeal will not lie before the DM. It will have to go before the commission.
Commissioner of
Therefore, even if you take him to be an interested party, which is then also in that case, argument. Next argument is that lease has in any case now expired by efflux of time. So he has no right even otherwise. And
Section 3 requirement is fulfilled.
Yes, yes.
That is the jurisdictional requirement for issuance of show
And
cause
you
notice.
relied on Justice Tandon's judgment on
Yes,
that.
yes.
That score.
Because there are 2 parts of it. Information received.
Right.
He has acted on information received given by the ADM.
Right.
And therefore, the first precondition of section 3 is fulfilled. If he has received an information, he only forms a prima facie opinion asking you to show cause.
Correct.
So
Now,
there is
now your next argument is it could be arbitrable only if it was it was a proceeding independent of eviction.
yes.
Once it is a proceeding for eviction, which is squarely covered by the Public Premises Unauthorized Occupants Act, it is hit by section 8A.
Yes.
Civil courts bar of civil court, and in at least in so far as the remedy will not be conclusive, in the sense that even if you get an award, you will have to get it executed through
Yes.
a civil court.
Civil
And
court.
if the bar of civil court is operating,
Yes.
which will operate in terms of section 8A, then in that case, it will remain a paper award. It will not be executed.
Executable. Because mode of execution is also provided in the act.
Right.
How it is to be executed. So even if you get an award, once you put it into execution, then again the bar of section 8 capital A will come into force, and execution will not be levied. That is the second point, my lord. And
I think that is.
yes.
Anything else?
Oh, and another one was that just a side issue, my lord, that the proceedings could not have been conducted in violation of the section 9
yes.
court order,
Yes, yes.
which my learned friend has
That is
pointed
right.
out.
That is right.
That
because
the proceeding with the show cause will
that is
result
in
in
the
violation.
That is just in the interim.
First of all, it is interim. Next, my lord, I had also shown
that you had shown that they are, first of all, you are not a party there.
first,
So second is that since it is
not me, SDM is not a party.
Yes,
Who is
right,
the author?
right. The SDM is not a party. I stand corrected. SDM is not a party there. Therefore, if there is an order which injuncts you from proceeding, that does not mean that the bar immediately operates on the SDM
Not
also
only-
to
yes.
proceed with the hearing. And next extension of your submission was that even if the DM proceeds for hearing, the SDM proceeds for hearing, till such time that any step is taken to actually change the status quo
Status.
for which the order was passed, it cannot be said to have been continued in violation of the order of status quo.
I am obliged.
That was
This is the thing. And then, my lord, the proceeding cannot be restrained by an order of civil. court. Section 41E of the
specific relief act.
specific relief act.
That-
So the order which has been passed by the civil court under section 9 is a status quo order to bind the parties to the proceeding, not to restrain any proceeding which is legally institutable under any provision. And my lord, lastly, my lord, showing the order of Justice Sarkar in the section 11 proceeding,
you said that
paragraph 7.
you have the points have been left open, and the very fact that it has been left open shows that it is not being governed by the
And
arbitral
there is
tribunal.
one line in that judgment which says that there is no view expressed on the propriety
So
of the
that
proceedings.
issue still remains undecided.
Yes. So
By
this
the referral court, because the referral court said that it is not for us to decide.
is gone into. Continuation or validity of such proceeding is not to be gone into by the referral.
Referral, yes.
That Well, I'll just, since it is already, Your Lordship has, on the first point, I would like to refer to one judgment on the point that merely because the adjudicating authority is holding a position in his official capacity, like a collector or a district magistrate, it by itself does not amount to a case of a person deciding his own cause. The principle of rule against bias will not apply. Just because he is a SDM or he is an officer of the state government and it is a state government land, so therefore he is deciding whether the land should be, possession should be given over to the state. So he is acting on behalf of the state for a cause of the state. That principle will not apply. This will not, yes. But I'll first refer to 2004 11 SCC 625.
Yes.
Kindly see. This was a proceeding initiated. Kindly see the first paragraph. Monies had been borrowed from Financial Corporation. Action was initiated on 32G of the State Financial Corporation Act. State government having appointed respective managing directors as authority under 32G, certificates of recovery were issued by the managing directors. Writ petitions were filed in Delhi High Court and Punjab and Haryana High Court, challenging the appointment of managing director as the authority and the certificates of recovery. So there were two views, Delhi High Court view and the Punjab and Haryana High Court view. Delhi High Court said that it was against the principle no man can be a judge of his own cause. Punjab High Court differed in the view. So in that question, my lord, it has come here. Kindly come to straight away, my lord, paragraph 5, which says about what is the view of the Delhi High Court. I am not going into that. Then kindly see paragraph 7. To consider which view is correct, one needs to look at the law laid down by this court. In the case of Nageshwara Rao versus APSRTC, a scheme was published by General Manager of the Andhra Pradesh State Transport Undertaking. Objections were invited to that scheme. Those objections were pursuant an order of the Chief Minister heard by Secretary to the Home Department. The Secretary to the Home Department then placed his note and comments before the Chief Minister, who then passed the order approving the scheme. Scheme was challenged inter alia on the ground the principle of natural justice is violated, inasmuch as the authority empowered to decide the matter could not have heard the objection. The Constitution bench of this court took note of the fact that the Secretary was in charge of the Transport Department. As such, he was also the head of the State Transport Corporation. It was found that the Secretary had been responsible for framing of the scheme, that he had then received and heard objection, made notes, presumably discussed the matter with the Chief Minister. It was noted that even though formal orders were passed by Chief Minister, the inquiry was conducted. Personal hearing was given by one of the parties to on these facts. It was held that persons who are entrusted with the duty of hearing a case judicially should be those persons who have no personal bias in the matter. On this fact, majority of the judges applied the principle no man can be a judge of his own cause and struck down, however, Justice Wangchu and EPC held that action was purely administrative. In such cases, it does not follow that the Secretary was an improper person to hear the objections. Next, your Lordship will kindly come to straight away paragraph 9.
Paragraph 9.
Placetum D. Fourth line from paragraph 9 top.
Yes.
The doctrine that
Yes.
no man can be a judge in his own cause can be applied only to cases where the person concerned has a personal interest or has himself already done some act or taken a decision in the matter concerned. Merely because an officer of a corporation is named to be the authority does not by itself bring into operation the doctrine no man can be a judge of his own cause. Of course, here, my lord, SDM is defined as the collector under the statute. Of course, in individual cases, bias may be shown against a particular officer, but in the absence of any proof of personal bias or connection, merely because officers of a particular corporation are named as authority does not mean that those officers will be biased. As has been held by the Constitution bench, a managing director is a high-ranking officer. He is not personally interested in the transaction. There is no question of any bias or conflict between interest and duty. In Nageshwara Rao case, the secretary who had framed the scheme then proceeded to hear the objection and advise the chief. It is because of the personal involvement of the secretary that the majority took the view. Even then, the two judges held it did not follow that he was an improper person to hear the. At this stage, it may be mentioned that control of the state financial corporation by virtue of section 9 vests in board of directors. Board of directors would take the assistance of the executive committee and the managing director, but the control remains that of board of directors. Therefore, there is no question of presuming there was any conflict of duty or that managing director would not act fairly. Then, my lord, your lordship will kindly come to paragraph 13. At 634. In the case of Accountant and Secretarial Services Private Limited was the Union of India, appointment and an officer of the respondent bank as an estate officer under the Public Premises Act was challenged on the ground that it was violative of Article 14. This court held that in the very nature of things, only an officer or an appointee of the government, statutory authority or corporation can be thought of for implementing the provisions of the Act. This court held that personal bias cannot be attributed with such officers either in favor of the bank or against any occupant who is being proceeded against, merely because he happens to be an officer. This is, my lord, the proposition, my lord, which we are advancing. 14. Does the authorities disclose that mere appointment of an officer of the corporation does not by itself bring into play the doctrine that no man can be a judge in his own cause? For that doctrine to come into play, it must be shown officer concerned as a personal bias or a personal interest or has personally acted in the matter concerned and already taken a decision one way or the other which he may be interested in supporting. This being the law, it will have to be held that the decision of the Delhi High Court is erroneous and cannot be view taken by Punjab, Haryana Court is correct. Will have to be held that managing director can be appointed as an officer under 32G. So, my lord, this is the test. Officer concerned must have a personal bias. The SDM is defined as the collector under the Act. So his appointment in this matter cannot be challenged as on the ground that he is an officer of the state. He is deciding the issue raised by a state body that the land is required and the land is in unauthorized occupation of another person. So this is one of the principle. I am relying upon one more judgment, a bit later judgment also. This
To protect the interest of state.
DM is the executive officer of the Jila Parishad, who is the owning the land. So if the Jila Parishad has to act, it has to act through the chief executive officer, who happens to be the DM in the instant case. And in the hierarchy of the state administration, SDM happens to be an officer subordinate to the DM. So this will not impart any element of personal bias in the matter. This is what it says. This judgment is this 2024 citation SCC online SC 3722. আমার প্যারাগ্রাফের সঙ্গে মিলবে তো? Kindly see, my lord, this is also a proceeding for eviction under Mumbai Municipal Corporation Act pending before the inquiry officer. Kindly see paragraph 3, my lord. Operative part of the impugned order expedites proceedings for eviction pending before inquiry officer under Mumbai Municipal Corporation Act against the respondent in the manner directed within 12 months. Direction could not have not left the appellant. However, they are seriously agreed for an altogether different reason. That is, the learned judge has framed points for determination by the inquiry officer. So, my lord, kindly see what are the points which have arisen here. Kindly come to paragraph 4.4.
Yes.
It is the recommencement of the inquiry proceedings which has ultimately resulted in the present round of litigation. Put on notice, respondents wished the inquiry officer to decide two primary contentions. Whether in absence of regulations framed under section 105H of the Act, proceedings should continue, whether the municipal commissioner ought to refer the dispute to an independent forum for a decision in a just, fair and unbiased manner. By an order dated such and such, inquiry officer ruled against the respondents. Against their respondents presented an appeal before the principal judge. Appellate authority refused to interfere, dismissed the appeals as maintainable, still aggrieved. They invoked jurisdiction of High Court under 226 and 227 and assailed the eviction proceedings premised on the same points that are raised by before the inquiry officer. Regulation not having been framed under 105H, proper conduct. Second one is important for our case, but institutional bias has vitiated the proceedings and the rule breached to the utter prejudice and detriment of the notices, inasmuch as the inquiry officer, being the delegate of the municipal commissioner, would be unlikely to derogate from the authority's decision to evict them. This is the specific plea, my lord, which is also raised here. Paragraph, kindly come to paragraph 27.
27.
Yes, 27.
27. Yes. Seventh point.
Seventh point raises the issue as to whether the proceedings are vitiated by institutional bias insofar as the same are being conducted by an officer of the first appellant. Answer to this issue is squarely covered by the decision in Accountant and Secretarial Service versus Union of India. This one I placed just now. Question which fell for consideration by the appointment of an officer of a nationalized bank in proceedings pertaining to eviction from the premises of the same bank would violate Article 14. This court, while upholding such appointment, held, paragraph 32 is quoted. Dr. Chitale, while initially formulating his contentions, outlined an argument provision in 71 Act appointing one of the officers of the respondent bank as inquiry officer is violative of Article 14. We do not see any substance in this contention. In the very nature of things, only an officer or appointee of the government, statutory authority, or corporation can be thought of for implementing the provisions of the Act. That apart, personal bias cannot necessarily be attributable to such officer, either in favor of the bank or against any occupant who is being proceeded against, merely because he happens to be such officer. Moreover, as pointed out earlier, Act provides for an appeal to an independent judicial officer against the orders passed by the inquiry officer. These provisions do not suffer from any infirmity. Then, paragraph 28 also, decision was affirmed in Delhi Financial Corporation versus Rajiv Anand. Paragraph 14, authorities disclose that mere appointment of an officer of the corporation does not by itself bring into play the doctrine that no man can be a judge of his own cause. For that doctrine to come into play, it must be shown that the officer concerned has a personal bias or personal interest or personally acted in the matter. Well, these judgments are all quoted. Kindly see para 29. Hyderabad Vanaspati versus EP State Electricity Board in way of profit, wherein the three-judge bench was tasked with examining whether adjudication of malpractice and electricity preference cases by officers of the very electricity board against whom wrong has been committed would constitute bias. While negativing such challenge, this court held principle nemo judex in causa sua will not apply in this case as officers have no personal list with the consumers. Pointed out, they are similar to income tax or sales tax officials. There is nothing wrong in their adjudicating the matter. Consumers may be represented in the formula for making it speaks in the clause. So, this is the principle. Ultimately, kindly see paragraph 31, which is the finding of the Supreme Court. In view of the above authorities, it is clear as crystal that if the officers have no personal interest in the least, bias cannot be imputed, especially since the officer is not acting in his capacity as an executive official, but as a quasi-judicial authority. So, this is the point which I wanted to show, that SDM's appointment, then the very definition of the collector will have to be challenged, because they are all officers of the state, and the act is intended for eviction of occupants from state property. And the constitutional various of these provisions have all been upheld. So there is no challenge can be raised as regards that. But one judgment, I just like to show on the aspect of challenge to a show cause notice. Once I can show to your lordship that the show cause notice or initiation of proceedings does not suffer from any jurisdictional infirmity, then the court will not go into the show cause notice. The proceedings are ripe open to be decided. This is very well settled by 2006 volume 12 SCC 28. Para 13 to 15. It is well settled by a series of decisions of this court that ordinary.
This is right. So show cause does not give rise to a cause of action. Nothing is decided.
Yes.
As yet. That's well settled.
Now I just take 2 minutes, 5 minutes to discuss their judgment. Kindly see the first judgment is 2013 7 SCC para 20 page 25.
দিদি আলাদা ফাইলে না রাখলে ঝামেলা হচ্ছে জাজমেন্ট গুলো।
Here, this was an order passed by the joint registrar of cooperative societies,
Yes.
superseding the board of directors of the cooperative bank without previous consultation with the Reserve Bank of India as provided under second proviso to 53(1). So this was a statutory violation. This challenge, if your lordship will kindly see paragraph 2, first line, board of directors
Yes.
Board of Directors of the bank challenged the above mentioned order on various grounds, including ground of violation of second proviso to 53(1) of the Act, that is non-consultation with the Reserve Bank of India before taking a decision to supersede the Board of Directors. So there was a statutory violation in the order, and that was a final order, not at the show cause notice stage. Now kindly see, my lord, here kindly come to paragraph 26. Show cause notice stage was not challenged. 26.
Yes.
Joint registered cooperative societies, as already stated, issued a notice to Panna Cooperative Bank to show cause why board of directors be not superseded and administrator appointed. Show cause notice was sent to RBI, which RBI received on such and such. RBI by letter requested the joint register to inform the action being taken on the reply submitted by board of directors. RBI forwarded a copy of the show cause notice to the general manager NABARD for their comments, since NABARD had already conducted inspection under section 35. Then, my lord, what happened? Kindly come to paragraph 7.
7.
Sorry, 27. 27. Thereafter. RBI again by letter dated such and such wrote to joint register to inform RBI the outcome of replies submitted by bank to the show cause. RBI then sent a reminder since no reply was received. RBI was seen as received a reply from joint register on 10th August. RBI then sent a communication to joint register to know the action taken on the reply. Joint register sent a detailed reply stating that in case of cooperative bank, order of suspension would not be issued without consultation with RBI. However, if no communication containing the views of RBI on the action received, it should be presumed that RBI agreed to the proposed action. RBI and the registrar would be free to pass orders. So on this basis, my lord, kindly comes thereafter another letter dated slightly below the bottom, yet another letter dated 24 December 2009 was also received by RBI, where it was stated that the hearing was going on, RBI would be informed of the final decision. Later, without informing RBI of the proposed action, also without forwarding a reply sent by the bank, the order of supersession was passed by the joint register. So this was a statutory violation of the provision. So in that context, my lord, my learned friend had placed paragraph 37 that joint, kindly see, joint registrar while exercising powers of supersession has to form an opinion. Opinion must be based on some objective criteria which has nexus to the with the final decision. So this is on the basis of a statutory violation. And number 2, my lord, kindly see here the factual aspect which is also noted in paragraph 28. Why otherwise the decision could not have been passed. That is also here. But your lordship has no occasion to that extent to see the decision. Here your lordship
is still at the stage of show cause.
And here section 3 only says that on the basis of information he will have to form an opinion for issuance of a show cause notice. And that opinion is only a tentative opinion, because he is finally asking that you show cause why you are not in unauthorized occupation. Here on paragraph 28, if your lordship sees, why no opinion could have been formed by the registrar, that is also explained in paragraph 28.
Yes.
28. I'm sorry.
Yes.
we find 7 charges leveled against the board of directors were relating to the period of the previous committee, for which first respondent board of directors could not be held responsible. So on facts also, the Supreme Court is saying that these were the, first of all, no statutory violation. Then the charges were against the previous committee. So on this basis, the court says that it has to be based on an objective criteria. And that was the final decision. Next, my lord, 2016 9SC 44. This is in relation to the fact of proceeding being in violation of status quo. The proposition, my lord, cannot be doubted. Your lordship sees paragraph 54. We are of the considered view as held.
You say that SDM was not a party, and in any case, it is not in violation of the order because the order had directed
status quo.
Status quo is not being changed only by
When the hearing proceeds, status quo is not being changed. Only when the question will arise whether execution can be levied. That argument is different. That then section 41 of Specific Relief Act will come. So therefore, my lord, it is, kindly see this line, we are of the considered view as held by this court that it is not open to either the parties to the list or to any third party to determine at their own that an order passed by a court is valid or void. The order is, SDM is not saying that that order is void, it is not valid, that is why I will proceed with the hearing. His proceeding cannot be affected by the status quo order directing both of us to maintain status quo. It's not a question of status, the SDM's proceeding contending that this order is non-est. That is not the case. So this proposition, no one can dispute. And it has to be if the party to the list or a third party who considers an order by a court is void must approach a court of competent jurisdiction to have the order set aside. Of course, it has to be done. SDM is not a party to the proceeding. Why will he go and approach the court for having it set aside? It is neither his contention that the order is not void. He is a statutory authority. He has initiated a proceeding.
But I think in the affidavit that Mr. Tiwari had filed, there was a letter on which he relied saying that the order could not have been passed or something.
That is my letter. Suppose, my lord,
But there was an observation.
Yes,
to that
yes, yes. SDM is saying the order is obtained by committing fraud. But can you see page 5? Page 5 of my supplementary affidavit affirmed on 19th of November 2025. Can you see page 5? Paragraph, last paragraph. That apart, so as far as order of status quo dated July 28, 2021, pending before the such and such is concerned, the same is inter se party and as such does not affect the pending adjudication in terms of the proceedings of so cause notice dated such and such issued by the subdivisional magistrate, which apparently prior in time more concerning is the fact that such order was obtained unscrupulously without disclosing the pendency of the proceedings under the Act of 1962, and this is nothing short of playing fraud upon the court. Now, next proceeding. In this background, in my humble opinion, there appears to be no impediment for the concerned authority to proceed with the hearing in terms of the proceeding comes so cause notice such and such. District Magistrate Murshidabad has thus instructed me to proceed under the such and such.
Well, I will give you, lordship, an example. This is whatever is there is there. Kindly consider there is a section 9 proceeding by the tenant against the landlord, and there is an order passed by a section 9 court directing parties to maintain status quo. In the meantime, the landlord has instituted a suit for eviction before a civil court. The tenant in the civil court shows the order of status quo and makes a prayer that the eviction proceeding should not be continued. Can the civil court not make a comment on the basis of submission of the respective parties that that order passed by the Section 9 court, in my opinion, has been obtained by fraud without suppressing material facts, and it is not an impediment on me to proceed with my jurisdiction. Here, Your Lordship, he is not, this is not as Malad in the Supreme Court judgment, he is a quasi-judicial authority. It is not a question of examining his status vis-a-vis the civil court. He is a quasi-judicial authority conducting a proceeding under Section 3 of the Act. A prayer has been made by a party to him saying that do not proceed, stay the proceedings because there is an order of status quo. Good or bad, he has passed, he has expressed his mind that order does not bind me. That order, on the basis of submissions, it has been obtained by procuring fraud. It cannot amount to usurpation of my jurisdiction. I will proceed with my matter.
Very good.
So, my lord, this will not anyway dilute that judgment. The judgment is clear. That is, my lord, it says that a party to a list has to come and say, he is not a third party. I am saying he is a quasi-judicial authority. A quasi-judicial authority will not apply for setting aside an order. So, my lord, this judgment will, with the greatest of respect, will not apply here. Because if we accept this contention that the proceedings had to be stayed and he had conducted an impropriety, that will amount to, my lord, violating Section 41E of the Specification Act. A person who has lawfully entered upon jurisdiction, initiated a proceedings, cannot be made to stop a proceeding because of an order by another forum against two parties. So, my lord, this is that judgment 2016. Then, my lord, there is, I think there is one unreported judgment. This is Supreme Court, my lord,
Sanjit Singh Salwan.
Yes, Sanjit Singh Salwan. Here, my lord, it is a bit different. Here, what they are trying to say is that if I had filed Section 8 application in the suit, praying for suit be stayed and for reference of the parties to arbitration, then I cannot take any other jurisdictional point. That the suit is also barred by Section 80 of the West Bengal Public Premises Act. Can it be said that? But then the principle is there can be no estoppel against law. Section 8 means what? The Section 8 has two criteria. Number one, the civil suit court has no jurisdiction. The ground cited is there is an arbitration agreement between the parties. But it is a jurisdictional issue which had been taken. Now, once the suit has been said that the suit court has no jurisdiction, if the party feels that he has another law or another right under a special statute, giving him a special right to invoke a provision, can I be estopped from doing it? There cannot be any estoppel against statute. Now, my lord, this judgment is somewhat else. Here, what happened, my lord, kindly see paragraph 3. Suit for injunction was filed in respect of a trust property, a school which was a trust property. Defendants filed application for rejection of the plaint. Plaint was rejected. Plaintiff preferred appeal. In the appeal, both parties entered into an arbitration agreement. Arbitration agreement entered into post-suit in the appeal. And an arbitration, then the appeal was disposed of, suit was disposed of on the basis of the arbitration agreement. Arbitration agreement, award was passed. Award was put into execution. When award was put into execution, it was said that there can be no award in respect of a trust property. So in that context, My lord, this is the point which has been raised. I have not permitted the award to be proceeded with, giving up my right under the Special Act. Mere filing of a proceeding under Section 8 does not amount to waiver of my right under the Special Act. I have only stopped the suit court from proceeding. That is the jurisdictional issue. So, my lord, this judgment, kindly see, this is the paragraph which has been referred to. Facts your lordship will get, then ultimately paragraph 9 your lordship will see.
Yes.
It was the appellant who sought to raise an objection to the jurisdiction of the civil court by raising a ground that suit was barred in view of Section 92 of the code. Application was opposed by the respondent. Trial court proceeded to hold that in view of Section 92 code had no jurisdiction to try the same. Case was rejected under Order 70. Then, during pendency of the appeal, respondent moved an application stating that the respondent as well as the appellant had decided to have their dispute resolved mutually. Then they entered into an arbitration agreement in the suit. That is a subsequent conduct. Ultimately, kindly see paragraph 14. Sorry, paragraph 13. After initial round of litigation, when the appellant sought to rely upon the consent deed and filed an application under Section 9 of the Act for seeking interim measure. Kindly note this. Not only that I have consented to the arbitration agreement, I have gone ahead and filed a Section 9 application seeking interim measure. The respondent took a completely opposite stand and raised the plea that compromise deed in form of award was a nullity in view of Section 92 of the code. They persisted with this stand, which found favor with the commercial code. Thereafter, in appeal to the High Court, the question therefore be considered that the respondents would be permitted to take a diametrically opposite stand. My stand is not opposite. Same stand, suit court will not have, civil court will not have jurisdiction. So, my lord, this is the distinguishing of this judgment. Then, my lord, the Central Warehousing Corporation has been relied upon, which I have also relied upon, that both acts will operate in the different field. Then, my lord, 2022 17 SCC page 81.
Yes.
Paragraph 18. This is a case of lease also, and it's a dispute relating to renewal. Then the court has held that the renewal dispute, kindly see paragraph 18, page 89. This had nothing to do with termination, unauthorized occupant. The dispute was whether they are entitled to renewal or not. The kindly see clause 4 Roman 13 provides appellant lessee shall in the last year of the lease tenure and not later than 6 months prior to expiry of the present lease communicate in writing to the lessor term and condition for the present lease is accepted by the lessor, present lease may be renewed. The arbitration clause cannot be rendered otiose by refusal of the respondent state to renew the lease. This is not our case. This line means that there is an arbitrable dispute. But here, once it has been terminated, if you are an unauthorized occupant within the meaning of the Act, can I not invoke the Act? This is the question. Prima facie opinion is because of termination and expiry, you have been classified as unauthorized occupant. You and the authority is the collector and SDM. Whether you should answer that show cause or not. This is the only issue. And I think, these are my but my learned friend had relied upon one judgment, not relied, said he will rely upon that Rolter. But this is a division bench, that order was challenged. that issue was not gone into, but on the question of territorial jurisdiction, the appeal was allowed and the order was set aside. So I just placed this judgment. So if it is cited, you can have taken note of that. Yes. The impugned order was passed under section 9. Kindly see appellant submission. Paragraph 3 was suit for land. Proceedings were not maintainable. Then, my lord, paragraph 3 also, your lordship will see. He draws the attention of the court to the notice dated September 2023 and submits that notice was issued under provisions of the 1962 Act. Learned senior advocate appearing for the submitted grant of injunction restraining the appellant to proceed under Act of 1962 reflects upon possession of the immovable property. Possessed property is lying outside. Proceeding is not maintainable in the original site. Then paragraph 8. Section 9 was disposed of without any affidavit. Finally, my lord, it has been disposed of on the basis of the paragraph 27 on the basis of suit for land. Paragraph 25. Appellant through the notice is seeking to obtain possession of immovable property concerned. Respondent seeking stay of such notice prevents the appellant from obtaining possession thereof. Paragraph 28. Central Warehousing Corporation held provisions of Public Premises Act does not override the provisions of 1996 Act. We are not minded to enter into such issue in the These are my.
Well, let the state also make his submission, my lord. Then will I'll give my lord composite reply. It is true, Mr. Saini is espousing the cause of the state, but let the state.
Happen to be the Jilla official. I cannot shy away from that.
So let the state
Yes,
will also
what is
submit.
this submission. What is your submission?
I take your lordship kindly.
Yes, yes, please.
Do your lordship prefer that we give any short?
Up to you. Entirely up to you. I have my notes. You want to give, you can give.
Oblige.
Yes.
So far as the state is concerned, pertaining to the order that's passed. Not pertaining to the order that's passed, not within the provision itself, there is a provision for appeal.
Which order?
Order to show cause, my lord. When it comes to page number. Page number 100.
Page 100, yes.
The order that is sealed here, on page number 100 of the writ petition, it kindly produces the order. We are still at the stage of show cause. The statute in itself provides the provision where they can prefer an appeal. They choose to override that. With regards to the section 9, the section 11 that they have preferred, we have not been made a party to it. That is my short and crisp submission. Mr. Dhor is leading me in this matter. Supratim Dhor is leading.
He should have been here because it's
He should
some time it is called. He has not been here any day. Never. Although his names appear, but he doesn't come. Yes. No, but I have to proceed. You make your submissions.
My lord, I'll concede to my learned senior's submission, whereas
You are
my lord,
adopting his
my-
submissions.
I'm adopting his submissions. And adding, my lord, only this point that there is a statutory provision for them to prefer an appeal if they are at all aggrieved by this order. They need
No,
not
but that is only after an order is passed. They are at the stage of the show cause.
show cause.
So the appellate provision is not yet activated for them.
And my lord,
It will get activated once an order is passed for eviction.
the rest, my lord, Mr. Shen has already submitted, my lord, I'll adopt that submission.
Will. Yes, Mr.
Today, my lord, let's start or your lordship?
Up to you.
Lord, on next Thursday, I have some problem, Lord. It can be on Thursday week. Next Thursday, I have personal difficulty.
You would have it at the but it was a flow and it would have been better for your lordship.
But if it's personally inconvenienced,
I understand.
Or any other day, if you lordship, I need 30 minutes time to give reply. Any other day. 7 except next Thursday.
29th we'll have it done. लिखिए. File it. If you file it, I'll record that. Don't worry.
Deep love.
Okay.
আলাদা আলাদা করে করে দিলে নাহলে হ্যাঁ ঠিক আছে অসুবিধা নেই আজকে সন্ধ্যাবেলা রাত্রিবেলা প্রসিড করে লিস্ট
Lord, I beg to appear. I am
Yes.
for the petitioner, Lordship.
Yes.
Made a
77.
made a 677. Made a application before the concerned authority. Unauthorized construction on public premises, Lordship.
Yes.
Ela dag number 5174, jail number 142, Moja
Mr.
Belpukuri.
Bhattacharya, you are appearing for whom? State.
Not private respondent, my lord.
Private respondent number?
Only 9.
9.
Omole Sadok.
Yes, what is your grievance?
Unauthorized construction
State, who is
on
paying
public
this? You are
premises,
appearing
Lordship.
for the state. No, you are with him.
My ingress egress is totally blockage.
Who is appearing for the state authorities?
It's 7451.
You are directed to serve again on the state respondents. You have served.
My Lordship, the private respondent served the
No, on 2nd of
Other.
December also you are requested to serve.
have the
Acha, state was present, yes.
lordship.
Jyoti Prakash
Earlier
Chatterjee
occasion,
was
yeah,
present for
lordship
the
was
state custody.
kept on record, lordship.
What is your grievance now, you tell me?
Well, adjacent my land, at the adjacent my home, unauthorized construction, private respondent. Totally engage and egress my blockage.
Unauthorized construction on whose land? On your land?
Well, adjacent my land, lordship.
Adjacent to your land means on your land, your private land.
My lord, my home.
Then how will this remedy be activated if it is on private land? Then that is a cause for civil dispute. It gives rise to a civil dispute.
Well, kindly see the page number 18.
1-8.
One sketch map.
No, this sketch map will not show whether it is
5174.
51.
5174 is path. My allegation is
It's only 74, not 5174. What? Path is only 74.
but this is the 5174. 74, but Mata 5174.
Where do I get 517? I can see 5173, then path is only 74.
Only 74.
It's not 5174. 7272 is Shali, 5177 is Shali, then 1 is Shali. দেখুন তো none appears for the state respondents. And you communicate this to the respondent number 7 also. You communicate this order. The petitioner shall also communicate this order to the respondent number 7. The petitioner shall also communicate this order to the respondent number 7 so that he comes to know about it. Maybe nobody is appearing. The petitioner shall communicate this order to the respondent number 7. Next, Cholu.
In this matter, Mother, the last occasion pursuant to your lordship direction, they have filed a report. So now your lordships are not satisfied that report, they have further called for a further report. So now, my lord, in this matter, my lords, it appears from the record. My lords, they shortcut the time today also, my lords. So my lord, my submission.
Wait. Your report is there?
No, Lord, he has not come to court till now, Lordship.
Who has not come?
He's for the state respondent.
Mr. Supratim Dhar did not appear on the last occasion also, although his name is there, but he did not appear. Somebody else had appeared. No, what does it mean till now he hasn't? Will he come or will he not come? Should I wait for him then?
Lordship, can't make it. Not today.
Why not today? Why? You need to give some instructions as to whether your report is ready or not. Don't take the court lightly. There is an order from the court to file a report in the form of affidavit. You will not comply with that. Ask him to come at 2 p.m. Next.
Yes.
Yes. I'm concluding hearing them. I'll pass my orders.
Your lordship was expressed his lordship's opinion that your lordship will
Yes,
dictate
but
the order.
it's almost 11:40.
Yeah,
Now I start dictating all
I
the
have
other
seen it.
matters will be held.
Tomorrow, let it appear as for judgment or for orders any day.
Yes, it will appear. It will appear once. Very well. Next.
My lord, this is my petition
I appear for the pro forma respondent owner.
challenging my lord an
I
order
have,
of
my lord, the main appeal, which is, my lord, I believe 782. 682, sorry, my lord. So, my lord, I think both can be heard too, because if I have a right, my lord, then it will flow to my tenant. Otherwise, not. So, my lord, if both the matters are taken up together on a day, then because today 682 lordship cannot, because I have an application for, my lord, amendment. Which is,
682 is appearing in the list.
yes, but
Just
my lord,
one
in,
matter after this.
yes, but in that matter, what had happened, my lord, we had filed a 227 application challenging the order. My lord, Justice Hiranmay Bhattacharjee, my lord, passed an order that to transform this into a 226. Now, my lord, we have, but obviously I have to change the prayers. Now, the department says, my lord, cost title you can, but unless lordship grants the leave, my lord, we cannot change the, my lord, prayers there. So I have preferred a separate application before my lord, which is the CAN in 682. If lordship allows that today and gives us, my lord, 3-4 days time, we can come back with the amendment and lordship can hear both.
I'm referring for respondent number 6 in the first matter, WBKIS, and respondent number 4 in 682.
These will all change. Page numbers will also change, my lord, after the amendment. So lordship keeps both the matters together and fixes a date, and we'll come back, because I cannot, my lord, have the, unless the amendment is allowed, I cannot change it in the department. And that is my can, my lord, today before my lord.
That can be done, Mr. Banerjee. There is an application for amendment seeking to introduce prayers because the prayers were originally in the form of a revisional application in 227, which now I understand has.
হ্যাঁ সেটা ডিপার্টমেন্ট এখন allow করছে না because that court no but that court cannot allow it also. 227 court could not have allowed it. That lordship has to allow.
So that is formal, that can be allowed because that.
So then lordship fixes a date, on that we come back, my lord, because it
So,
will take,
let me
today
do
is
a
my
step further
Thursday.
so that it is all ready. I can allow CAN 1, the amendment application, so
Yes.
that by the time we meet next, this.
Yes, this will be done, because I have, my lord,
proceeding
prepared
for
it.
hearing.
It's ready. It's ready, my lord.
Only thing you lordship not record any consent from my side, but you lordship will.
Obviously, one.
No,
This
I
is
will not record.
lordship
I will
direct.
I will say it's formal in nature, only introduction of prayer. By a judicial order, it has been converted from 227 to 226. So there is no hurdle in entertaining.
And lordship will direct the department, none of us, my lord. It's the department who is to act in terms of my lord's order for the amendment
No,
part.
for introduction of prayers and all, I think you will have to file.
Yes, I have made that ready. That's part of my application.
So that you will have to reaffirm and file.
Yes, of course. That's my prayer, my lord.
That you will do.
My can is with regard to
Because
that.
it's not to be.
No,
captured
not
by
at
hand
all.
and all.
No,
So
no.
once
It
is
has to
done,
be
the department
reaffirmed
will
and
have
file
nothing to
afresh.
do, actually.
My lord, that is why I'm saying, my lord, the page numbers will all change, my lord, and everything will change in my writ petition.
I'll say that you will amend it, file an amended writ petition upon reaffirming it.
And this
Only thing is, my lord, what I find, which I was asking yesterday night also, there is a WP number already given in my application, my lord. If
So
your lord,
that WP
that
number,
yes, that should be maintained.
that will retain.
It not have a fresh.
The writ petition is not going out.
Correct.
The writ petition is being amended.
Yes.
And
yes.
what is being amended is only the prayer.
Absolutely, my lord.
So therefore, the cost title and the WP number won't change.
Correct.
At a 682 tag to call করুন।
I am appearing.
আচ্ছা। আসুক এই অ্যাপ্লিকেশনটা আসুক।
CAN number টা বলুন। The CAN number is CAN 1 of 2025. In WPA number, my lord, the 18846 of 2025. কি?
ভারী আছে নাকি?
হ্যাঁ।
একটা দিন হাফ হাফ করে দিন, হাফ হাফ করে। ওরে বাবা। আর না আপনি দিন।
আরে তুলতে যাবেন।
হ্যাঁ, because
আবার ঠান্ডা লেগে যাবে আবার খাতা।
I think lordship can only take the CAN, my lord. CAN application is very thin, my lord. এগুলো তো সব ওই ডকুমেন্টস নিয়ে WP এর এটা ক্যানটা দিলেই হবে। CAN 1 of 2020। ক্যানটা তো পাতলা।
Yes, yes.
Well, kindly sees the can, man.
He can nahi.
Can nahi. It's appearing in the list, man.
Yes, it appears, but at times it's not there in the file. In several other matters also. it has-
682 তে থাকবে।
একটা অর্ডার রেকর্ড করুন, ক্যানটা ফাইলে আনুন। 682 তে অর্ডার রেকর্ড করুন।
Or should I hand over my can, mal, or lordship
Let
get?
it come because I should have it in my records also. I
Oh,
don't know
very
where it is. 682, can 1 of 2025. Now it is submitted by Mr. Banerjee, learned
Lordship, I am for the petitioner, Lordship. In this matter, Lordship, as per your Lordship's leave, Lordship, we have added the Jila Parishad as a party. We have served upon them, executive officer and Jila Parishad itself. And when we have sent 3 times, Lordship. Thereafter, we went there to post by hand. They are not receiving the copy, as we have not made party the Shabhapati. So, Lordship, as per your Lordship's leave, we need to add the Shabhapati itself. Then we can send them copy.
Hooghly Zilla Parishad has been served.
Jila Parishad has been served.
You are appearing for Hooghly Zilla Parishad?
No, my lord, I am for the private respondent number 11.
Lordship, here the road belongs to Jila Parishad, Lordship. They are claiming.
Why is Hooghly Zilla Parishad not appearing?
We have served executive officer and Jila Parishad itself. But 3 times they refused to receive the same. Why? Because when we went there to make the hand service, they are saying that you need to make Shabhapati as a party, Shabhapati of the Jila Parishad as a party. So he is not there.
As prayed for by the petitioner, let
I am for the petitioner. I have sub copy. The service has been effected.
yes, who is appearing? Who is appearing for the state?
Mr. Galib appearing.
Can you bring him? I'll pass it over. You bring
Yes,
him.
yes, my.
Pass over করে রেখে দিন। এটা affidavit of service টা ফেরত দিন।
My lord, I am for the petition.
Private respondent.
Why state is not appearing in any case?
My lord, on last occasion, your lordship directed the BLRO to make an inspection. My lord, inspection has been done. My lord, the state is supposed to file a report.
I am for private respondent number 9.
Mr. Devra, state is not represented throughout. Why? In most of the matters, state is not there. Somebody had appeared, Mr. Dokko had appeared. Shopon Kumar.
Yes, yes, my lord.
On the last occasion.
Sulogna Bhattacharya and Shopon Kumar Dutt.
On 20th of November, they had appeared.
My lord, on last occasion, my lord, Miss Sulogna Bhattacharya informed me that report has come. He is carrying the report. My lord,
Maybe they are held up somewhere then.
My lord, may I call back and come back at 2 p.m. my lord?
2 p.m. may be difficult because
Then my
2
lord,
p.m.
just
original sir.
just call him.
Pass over. Thank you.
For the petitioner, my lord, I am submitting affidavit service. My senior is online, my lord.
Lordship, I am for the petitioner, Your Lordship.
Yes.
Lordship, in a matter proceeding under West Bengal Public Land Eviction of Unauthorized Occupants Act 1962.
Yes.
The respondent number 3 has passed an order under section 4. Your Lordship would find it at page 37, Your Lordship.
Yes.
Petitioner is aggrieved due to the non-execution of that order. The order was passed way back on 9th June, 2025. More than 6 months have elapsed, Your Lordship.
Are you aware whether any appeal has been preferred against this order or not?
No, Your Lordship.
Who is appearing for the state here? What has happened? Why are the state respondents not represented at all?
Lordship, even before mentioning this matter before Your Lordship, we served notice upon them.
Likhun একটা order likhun. None appears for the respondents despite service. Full stop. Paragraph. The petitioner complains of inaction on the part of the respondent state authorities in executing and implementing an order dated June 9, 2025, passed by the subdivisional magistrate in a proceeding under the West Bengal Public Land within brackets eviction of unauthorized occupants bracket closed Act, 1962. Full stop. The petitioner shall serve a notice on the office of the learned government pleader intimating that the matter shall be taken up next on January 22, 2026, when it is expected that the state respondents shall be represented.
I have submitted affidavit service, my lord.
Affidavit of service filed today be kept to the record. উপরে লিখো।
Number 6. But I enter my apology. I'm coming from court number 19.
কল করে দিন তো এই পাস ওভারটা একটা যেটা ছিল 680 কত ছিল?
684.
Grateful to Your Lordship.
684 দেখি।
Matter led by learned GP Malar. On the last occasion, there was an order for filing a report. Malar, the report is ready. And but this is I'm sorry, Malar, this is the report. That is the further communication to the officer in charge by the BLM NRO, where the report.
এটা অনেক
না পরে দেবো Lordship kindly takes up the report dated 4 December 2025, my lord. My lord, here the plot in question has been encroached and the plot is identified to be in Khotian number 1, that is the vested land.
Yes.
The pain is that there is a power of attorney which has been mentioned in this petition upon which this application has been filed by the petition. It is a development power of attorney. But I am staying there for last 40 years. Now
that doesn't give you right. If it is a
No,
private
no,
land, see, the SDM will initiate proceedings. You make whatever submissions you have to make before the SDM. I am not going to decide the legality of your possession and occupation. It is within the right of or within the authority of the SDM under the West Bengal Public Land Eviction of Unauthorized Occupants Act. He will initiate proceeding. You will get a right of hearing whatever you have to say.
allow me to participate in the hearing.
Definitely, you will. You will be heard. লিখে নিন।
My lord, may I, my lord, copy of the report?
is being encroached by the private respondents, and they are they're constructing shop rooms, and it is being used for commercial purpose. Lordship, then we were compelled to file a writ petition for removal of the encroachment because it was creating obstruction, it was blocking my free ingress and egress. That is why we had filed a writ petition. Pursuant to the order, his lordship was pleased to pass an order directing us to approach the SDM for removal of the encroachment. And lordship, we had made representations pursuant to that order, but thereafter, lordship, no steps have been taken. Lordship, then again,
Yes,
we are
sir.
before your lordship, but just one thing,
What is the
lordship, on 9th of January, a notice has been issued for joint inspection, for demarcation. So lordship, I am praying for an adjournment, but not disposal of the writ petition, because we have to
Why?
see.
They will take steps. If they find
No.
that there is a encroachment on government land, they will
lordship-
take steps. I'll direct that. Why will I keep
My lord,
unnecessarily pending?
Just lordship, one thing.
before placing the report, my lord, may I show your lordship, my lord, only my lord, paragraph 21 of the writ petition,
Yes.
which my learned junior has indicated a few minutes ago. Page 15, my lord, paragraph 21. Your petitioner states that pursuant to the undertaking given by your lordship before the honorable court, your petitioner took steps for removal of encroachment, but due to resistance of the two persons, namely Akash Rai and Mr. Farhad Hussain, the respondent number 15 and 16 here in the said encroachment could not be removed. The said persons running their business from the said portion. The said facts was intimated to the concerned police authority while later dated such and such, my lord. So, my lord, they are not approaching the writ code, my lord, with the clean hand, my lord. It is
Why?
my past submission, my lord. Because
Why do you say they are not approaching with clean hand?
because, my lord, it is mentioned, my lord, in the previous order that they are also the encroacher. They have encroached a few portions of the land. And my lord, not only that, my lord, my concerned officers, my lord, has already taken place, had already taken steps, my lord. My lord. Third paragraph, my lord, is important. After the aforesaid activities, may I place, my lord? কোড ডাইরেকশন দিলে তখন দেখো
Yes. What has happened? Joint inspection has been done.
My lord, it has all, my lord, there is no such specific instruction with this regard, my lord. I'll come back, my lord, if your lordship so directs me within the further instruction. So what has happened, my lord?
My lord,
I have received this instruction as yet.
19th, the date has been fixed for joint inspection.
Oh,
19th.
19th.
My lord, 19th.
So if whatever unauthorized construction is found, you take steps against whether it is petitioner or where is the earlier order of this court?
My lord, is that
For giving personal hearing, my lord.
my
Page
lord, page
141.
141.
Hmm. 142, my lord. Last paragraph is relevant. In view of the above, the petitioner shall be at liberty to approach the concerned SDM praying for removal of encroachment.
Why? How has the SDM decided the representation of the petitioner?
My lord,
My lord, just one thing I'll just indicate to your lordship. My lord, we had approached the SDM prior to that. We had all because we wanted to demolish the unauthorized construction, which because while constructing the hospital.
In terms of this order, did you approach the SDM or not?
Lordship, we had approached because.
Where is that? I just wanted to see that.
Annex, page 145, Annex P16.
Page 145.
145.
How has the SDM decided this?
On
by passing order.
Where is
hearing notice was issued under section 3(1), lordship. But thereafter, no steps have been taken.
Page
Note-
152, my lord.
Page
P18.
151.
Page 152.
151, Lord. No.
P18.
Page 154. The hearing notice.
The hearing was taken on 16th of July 2025.
I'll have to take instructions, Lordship.
Why?
on
It
that.
is your writ petition. You should have taken, you have filed the writ petition. You don't know whether hearing was
But
taken
Lordship,
or
no steps have been taken. That is why after that we were compelled to file this
what
writ
happened
petition.
on 16th of July then? Where is the averment in the writ petition regarding that? There is nothing. You have filed this writ petition in November 2025.
Lordship.
So say what happened on 16th of July 2025? Where is your instruction on that? File a supplementary affidavit bringing on record what happened on 16th of July 2025.
My lord, but just one thing, Lordship, but we had approached for demolition of the encroachment.
And why have you not yourself demolished the unauthorized
Lordship, we
construction
had
that you
taken
have?
steps, but we were obstructed by Mr. Akash Roy and Mr. Farhad Hussain. Thereafter, we had also made a representation to the inspector in charge, Lordship. It is at page 144. Thereafter, page 155, we had again approached the SDO and the district magistrate at
Why
page
are you not
145.
assisting them in
Lordship, we had taken
removing
steps.
the encroachments that was made by
My
the
lord,
petitioner?
there is a dispute, my lord, with regard to the title of the land. My lord, so far, and because of that reason, my lord,
No, that encroachment is not on public land.
my lord, that's why, my lord, the LA map has been short for, my lord. If
My
your
lord,
lordship
the
will
PLR
kindly see, my lord, under such circumstances, the undersigned further directs the BLLRO, Sonarpur, by date office memo number 31002 dated 23/12/2005 to pursue with the special LAO South 24 Parganas for arranging the required LA map, and after a joint inspection needs to be held by the executive engineer Metropolitan Drainage Division 2 with the assistance of BLLRO Sonarpur with the help of LA
Very
map
well.
as early as
When is the inspection scheduled to be held?
19th January, Lordship.
I am fixing it after 19 January. In the meantime, you also come up with a supplementary affidavit and you file whatever you have to file.
My lord, one thing.
Yes.
My lord, kindly comes to page 107 once.
Yes.
His main agent, petitioner made, he also made private respondent, the main agent, the Akash and the Farhad Hussain. They are the petitioner's relative, and they also enforce the government plan. They, in this writ petition, they make the private respondent there, and they are not have the copy to us. Even we have not.
You are appearing for whom?
I am appearing respondent number 12 and 39.
Who are 12 and 13?
Here in SDM court, the hearing is going on. They suppress the matter, and this is the my lord, the land 509.
Who is appearing for respondent number 15 and 16? No, 15, 16?
15, 16.
Akash Roy and Farhad Hussain?
We have served upon them, but I think it has returned.
Complaint. They dictate that they engage them to remove the unauthorized construction, but they enforce them. The Farhad Hussain and the Akash Roy, the main agent of the petitioner, and they
My lord, one thing.
make them the private respondent and suppress the fact and make another in same ground. They previously the read at disposed and order to hearing on appeal court.
My lord, kindly comes to page 107 once.
Suppressing the fact, my lord.
Please wait. 107, yes.
My lord, the report of the BLRO, it says that the subject lot has been encroached by the respondents, who are the private respondents in the instant case, by constructing shops and semi-permanent structure, causing problem for the ingress and outress of the adjacent plot holders. Not only that, but also the encroachment has narrowed down the road, causing the road more accident prone. From the report, it is further evident that the petitioner, being a doctor by profession, is constructing a hospital on his own plot adjacent to the subject plot. The encroachment by the respondent is also creating vehicle movement for the
Very well.
construction
That
work.
will all be decided in the proceeding.
My lord.
Let us see what happens in the inspection. This writ petition has been filed alleging
May I file the affidavit of service matter? Lordship, the matter relates to the illegal encroachment made by the private respondent over government vested land, your lordship.
Who is appearing for the private respondent?
My lord, I am appearing for the state.
Now, lordship, pursuant to the complaint, an inquiry report has been submitted by BLRO dated 14/5/2025, that is at page number 31, your lordship, where it has been clearly indicated that the private respondent has encroached the government land. And kindly come to page number 31, your lordship. Paragraph number 4.
Yes, sir. Why have we not acted if there is a report of the BL and LRO?
My lord,
If there is a report of the BL and LRO saying that there has been an encroachment,
Paragraph
why
number
has the
4, yeah.
SDM not acted as yet?
that we have to take because we have only got the instruction from the police authorities.
No, no,
They
police
have-
authority will have
they have
nothing to
nothing
say
to
here.
say.
The SDM is the authority who will take steps.
My lord, there is no communication from the BLLRO, my lord, to me.
To take instructions
My lord.
so that it can be done. None appears for the respondent numbers. For the respondent number 12.
And I am for the petition Amala. This is the affidavit of service.
We appear on behalf of the private respondent matters. Primary matters.
Lordship.
Lordship. I gave the report, evidently annexing the document which has not been disclosed by the petitioner. So now they are alleging that I have made the unauthorized construction on a government land. That is not true. I have bought the land by the under the government by Patta. So now, on the basis of the Patta Mala, I have constructed the subgroup Mala, the dilapidated condition room, my lords. So not a Paka construction. Now, subsequently, they have purchased the land on the basis of their purchase deed, that is the government land. They try to my lord evict without approaching before the state. So now, invoking the jurisdiction of my lord is the West Bengal unauthorized.
Yes, Mr. Debray.
Manu.
You have instructions on this?
No, my lord, lordship, direct me to take.
I will direct.
Take.
So my
Give your.
I have only one submission before your lordships. Well, this is the document I have handed over to my director.
Lordship, direct the authority to inspect the.
I will direct that. I'll call for a report.
Yes,
From the BLL.
after inspection, physical inspection.
My lord, I am for the petitioner, my lord. The private respondent constructed unauthorized construction over the government land lordship in front of land.
Very well. I'm calling for a report from
Lordship,
BL and LRO.
Lordship.
After inspection.
Because his contention is that he has got that land by way of a patta from
Yes,
the
Lord.
government itself.
Yes, lordship. Lordship, kindly indicate lordship. Kindly come to page their supplementary affidavit lordship.
Yes.
Kindly come to page number 5 lordship.
Page 5.
Yes, lordship.
Yes.
Lordship, kindly come to paragraph 4 from the from the top lordship. I am reading lordship. উক্ত রায়ত নিম্ন তফসিলি বর্ণিত ভূমিতে কৃষিকার্য করিবার উদ্দেশ্যে 1955 সালের পশ্চিমবঙ্গ ভূমি সংস্কার আইন অনুসারে রায়তি সত্ত্ব পাইবার জন্য পশ্চিমবঙ্গ সরকার অতবার সরকার বলিয়া উল্লিখিত নিকট আবেদন করায় এবং উক্ত রায়ত উক্ত ভূমির রায়তি বন্দোবস্ত পাইবার উপযুক্ত বলিয়া জেলার সমাহর্তা অপর শাসকের প্রভৃতি হওয়ার সরকার নিম্নলিখিত শর্তে ও করারে তাহাকে রায়তি সত্ত্ব অর্পণ করিতে স্বীকৃত হইয়াছেন। মালা, they specifically mentioned that land should be used for the purpose of agriculture, not residential or commercial, but they constructed 2 rooms lordship without permission from the concerned authority lordship, which is mentioned lordship under section 4C of the West Bengal Land Reforms Act 1955 lordship. But they have not get any permission, Lordship.
But in that case, this will not
Purely-
fall under the jurisdiction of the
Yes,
public-
purely
public
civil
jurisdiction of
dispute.
unauthorized. That is a violation of the West Bengal Land Reforms Act.
Mother.
For that, you will have to initiate
Elect
separate
it.
proceedings. That will not fall under the jurisdiction of the
Unauthorized
SDM.
occupant.
Lordship, but the constructed government land lordship, the concerned authority also issued a notice in respect of me, Lordship, and and on that day we have gone there, Lordship, and I have supplied the
No,
relevant
but then,
documents.
what is your prayer here in the writ petition?
Yes, Lordship.
There is considered the representation.
Consider my
It's
representative.
unauthorized construction made by government land on government land. This is only if they are in unauthorized occupation. The occupation is authorized. The user is unauthorized. That is your contention.
Lordship,
So user, he is not the appropriate authority anyway. Since you have tried your best, I am asking them to bring a report.
my lord.
Let the report come.
Let the report come.
I correct, my lord.
So why are you wasting time on this?
Report must be come who are in occupation of.
All.
Including my lord,
This writ petition has been
After
filed.
inspection report will come.
বাচ্চাদের সাবমিশনও করতে দেবে
difficult. Only on 29, maybe at the first matter, 29. Only this must request.
My lord, only I am praying for inaction.
My lord,
This was
I
made
understand.
a page text.
Something to say, let him, since he is a private respondent, is लिखे in, since an adjournment has been prayed for, an adjournment has been prayed for on behalf of the
My lord, I'm for the petitioner. My lord, this is my affidavit on service, my lord.
by 22nd you will get it.
My lord, there is a unauthorized encroachment by the private respondents. on
Right.
the
So you
government
get the
land.
instructions and who is appearing for the private respondent.
That I don't know, my lord. This
Very
is
well.
the
You
first
give
time
the
it
affidavit
has-
of service. I'll record. Affidavit of service filed in court today is আবার কি হলো? ও হ্যাঁ next.
In this matter, I am for the petitioner. But I have served upon
Oh.
all. I have served upon all service has been effective.
Lordship, I appear on behalf of the private respondent.
I have filed this writ application on the basis of inaction on the part of the respondent authorities regarding unauthorized construction, page 24, my lord.
Page 24.
23 and 24.
23
The land has been acquired.
What has happened?
Land has been acquired by the authority, land acquisition collector.
And this is under the occupation of the private respondent?
Yes, my lord.
Yes, sir.
Lordship, two things. First and foremost, your Lordship knows that for the application of this act, it has to be an unauthorized occupation. I am here by virtue of a registered deed of conveyance which they have annexed to the writ petition. That is there. I have
Registered deed of
given the
conveyance by a
construction, your
private
Lordship, I have- Yes,
registered deed of conveyance by a private party.
yes, your Lordship.
If the land is of government character of which ownership lies with the government,
Yes.
how can a private party
Lordship, we
transfer
have
it?
the authorization from the government. We have been paying khazana to the government, to the collector. We have all the papers. If required, we will put in an affidavit that is there.
No, not before me.
But even before
Let the authority consider it before the authority.
Yes.
that is our
Let-
your
let-
it has
let
to
the
go before
authority
the collector. Collector has to consider.
Let it be
We
considered.
will put
Yes,
these documents.
Yes,
yes, my lord.
that is what I'm going to direct.
Yes, my lord.
This writ petition alleges inaction on the part of the I'll correct it.
Yes, madam. I'm there.
Yes.
93, I'm for.
My lord, I am appearing on behalf of the petitioner, my lord. My lord, first, my lord, prior to open the brief, my lord, my advocate on record is not present, although she is my chamber junior. If your lordship allow me, then I can proceed.
Yes, yes, fine.
My lord, this is the affidavit of service.
Before that, I'm for private restaurant, so far as east is concerned, the determination is concerned, this matter does not fall under your lordship's jurisdiction. It is a highway matter. Page 73.
Under 1962 Act.
Under 1962 Act, it does not cover page 73, you know?
Yes, page 73.
Para 3 and 4. And we got section 7.
It's a land matter.
No, this is highway matter.
My lord,
highway matter means?
Highway matter, this allegation is that beside the highway, the unauthorized construction has been made. Your lordship does not have the jurisdiction. Madam,
It is not in respect of 62 Act.
No.
Oh, it is in respect of 1962 Act, my lord. My lord, I have the property in front of my property, my lord, over the PWD land, the unauthorized construction raised by the private respondents, by which the obstruction is created to ingress and egress to my property.
Section 7, section
But does not include a government road or a highway within the meaning of Bengal Highway Act. So it's a highway.
How?
Oh. If it is a highway, then I will not have determination. Page 73.
Page 73, this is the letter written by the executive engineer to the executive engineer, highway division, to the DLNL. Page 73. Para 3 and
No,
4,
but it says encroachment over PWD land.
Yes.
First paragraph.
complaint is there.
Huh.
A complaint received.
Where is the conclusion that it is a highway land?
DLNL Sonarpur by memorandum such and such, dated such and such, requested to assistant engineer Barikul Highway Subdivision to provide necessary land schedule.
Yes, but where is this conclusion coming from? That from this, how do you conclude that it is a highway land?
No, actually, that needs to be decided by the authority. But as I am a recipient of that,
Who is appearing for the state authorities? Who is appearing for the state?
This is highway land.
That is your submission. As his submission is, it is public land. Your submission is highway land. There is nothing concrete. From this, it does not appear that merely because he has asked somebody to submit a report, it will become a highway land. No, it can't. Because he has asked others also to submit a report.
State Highway 1, Naranpur Road, State Highway 1.
It says PWD land. It doesn't say highway anywhere. They might have asked it for asked for assistance from somebody from the highway, but that does not make it a highway land.
Lord, the land belongs to
state will be
PWD.
able to clarify it.
One
State
opportunity, just one. Similar shop owners got notices from the highway authority and under highway.
Where is that? Show me.
That I didn't carry.
And who is appearing for the state? State will be able to throw light on.
Sharp, my lord.
It needs to a certain.
Very well. You serve a notice. I am passing this order. It is submitted by the learned advocate appearing for the private respondent. দিয়ে দিন।
My lord,
Passed over, it was passed over. I'm taking it up, then I'll call the regular meeting. এই 680 এটা একটা অর্ডার রেকর্ড করে নিন।
680, my lord, I appear for the petition.
682
This court has started hearing, and hearing has not yet been concluded. The subdivision is requested to postpone the hearing fixed on December 23 to a date
Later than the date?
later than the date on which the writ petition is made returnable. That date is
Today.
no, there is no date fixed. 23rd, the matter was taken up. Now, my lord, I have been informed by my persons, my lord, who were present, my lord, that there was a verbal, my lord, discourse made by the subdivisional officer indicating that come what may come on the next day. That is verbal.
Lordship is hearing the matter.
Now, my lord, today, I will be requesting your lordship that a similar order may kindly be passed. Requesting, my lord, a date to be fixed after 29th of January.
Yes. Yes. Full stop. এইটাতে লিখুন 556 কত ছিল যেন 17280 item 6
We are appearing for the private responder number 10 and 11.
Here, already, they have thought kindly.
Lord, I am challenging this maintainability of the petition. This is not maintainable.
Why?
Why, my lord? Admittedly, my lord, in their paragraphs, they stated that we have allegation is that private respondent enclose certain portion of the land.
Yes, government
Their
land.
land. Their
No,
land.
not
My lord,
also government land.
I shall so. Then, my lord, he has to file
No. Paragraph 11, he has said public land as well as land of
as well as
so far as public land is concerned, it is
my lord,
maintainable.
the public regarding the public land. My lord, I shall show, my lord, that we have already obtained the pattas.
That you will show before the authority
Yes,
concerned. If he gives
Page
notice,
21, page 21.
what has happened?
Thereafter, page 24, the subdivisional magistrate requested the subdivisional officer to take steps My lord,
Yes.
till date, they have not taken any steps, my lord. Page
But
24, my lord.
24, my lord, says
Yes, my lord. Yes.
SDLRO is no authority. My lord, SDLRO is no authority.
Subdivisional magistrate himself should consider. Why
Yes,
should
my lord.
the
Yes, my lord.
SDLRO consider? And where is your representation?
Page, my lord, page 21, my lord.
Page 21.
Yes, my lord.
My lord,
Second
second
You will be
paragraph.
heard. You will be heard there.
Yes.
You will be heard.
My
I'll
lord.
provide for that. The I was supposed to upgrade it.
I have one problem. Make survey thereafter.
So you make a prayer, I'll adjourn it.
By item is 295.
Not a problem.
295 lots will not take
No,
up.
no, no, no. Only his I will take because. না না ওনারটা একটা করে দিন, ওনার তো উপরে আসার কথা ছিল, আমাদের ভুলের জন্য আসেনি, তো আসার কথা ছিল, আর্জেন্ট ম্যাটারে আসার কথা ছিল, উনি মেনশন করলেন দুবার। No other matter will be called on. He had mentioned it on the grounds of urgency. Original
Pass over my land.
next step.
Next.
This is my evidence.
Where is your other side? No, only Union of India. There is no other side. Union of India is the other side.
Yes.
You are the effective respondent. Yes.
I beg to bring to file supplementary affidavit for subsequent.
What is the matter? First, tell me that.
Matter relates to the respondent authority allocated shop room in favor of the petitioner in the year 2012 under the leave and license agreement. And thereafter, the leave and license agreement extended from time to time. In the year 2005, that was lastly extended for a period of 11. During the subsistence of the said period, issued a notice for vacating the shop room. Against the said order, the petitioner challenged before this Honorable Court passed an order and directed the petitioner to make a detailed representation and consider the same and pass a reasoned order. Again, passed an order that is the subject matter of challenge.
Where is that?
That is the page 98, annexure P10.
Yes.
Yes. You are also para 5. You are also advised to hand over the shop to GE Alipur and confirm to this office by 18th January 2026 without pay. What happened? Prior to that, on 12th January, the respondent authority padlocked the petitioner's shop. And Lord, kindly come to page 79.
Let me see what the order said. What is the order?
Order at page. Prior to that, kindly come to page 79.
No, wait. Let me see the order. Your representation is in terms of the order.
Yes. Page 80 starts from page 80. Order. That is annexure P8. And relevant portion, that is para 14. That is at page 84.
84.
Yes. May I read it?
Where is your right
My
to
right
continue?
approves. Obviously, there is a right. Lord,
Nothing.
Come to page 79. 79 for a moment.
Yes. Please wait. I'll come to you.
Page 79.
Yes.
The respondent authority in one hand took the rein for a period of license fee for period July 2025 to March 2026.
Yes, sir. How have you accepted the rent till March 2026 if you want him to vacate in
That
January
includes my right.
2026? I have seen the order. But why did you accept the rent for March till March 2026? What is your answer to this? Till March 2026, why have you accepted the rent? If you did not want him to be in possession after January, why did you accept rent till March 2026? You take instructions and come back on Monday. Monday. Yes, Monday. Tuesday. Wednesday, no. Come on Tuesday. Why? Every day you will be in difficulty. Where you are then? এটা কন্টিনিউইং ম্যাটার হিসেবে দিয়ে দিন তো it has been closed. Bear it for 3-4 more days. I cannot bulldoze them without their instructions.
Type of action challenged by the one party and went up to the appeal court directed to prepare status quo prior to locking the shop.
Show me. দেখি if you have accepted, you should not have accepted the rent. Please mention it before that bench. It will be listed again, considered. Yes, next. Original site. কোনটা বলুন তো? দেখি তো কি হয়েছে, তাহলে ওটা রিলিজ করে দিবি। 463
Affidavit of service file.
না না, রিটার্ন করে দিন, অ্যাফিডেভিট অফ সার্ভিসটা রিটার্ন, অ্যাফিডেভিট অফ সার্ভিসটা ফেরত দিয়ে, এই তো এখানে দেখি। Group 7. I don't have determination. Yes, this court lacks determination. Yes,
My lord, I what foreign from your lordship, my lord. It is
where is the
better.
instruction?
But I have got the instruction. I have, my lord.
No, I want to keep that on record.
But
That
they
is
have
why
sent. He has sent me in mail.
Bring a printout. I kept it for that only.
I shall supply it. I will to your lordship officer, my lord.
I'll have to take it on record and
I shall give it to your lordship officer to keep it in record, subject to lordship pleasure. I have got.
I need to see it to dictate the order. Pass over করে দিন, you bring it.
Yes, I bring it. I bring it.
Next.
May I please, madam?
Praying for not today because my senior PK home week is right now.
My lords, a small legal point. I'll not come in the way, my lords. Notice has been issued to a non-existent entity, my lords. Notice has been under reassessment. Notice for reassessment has been issued to the non-existent entity. My lords, it's covered by my lord's order.
This property, Mascara Properties is not there.
Mascara Properties is my lords the resulting company.
Acha, the transferor company.
Transferor company. The notice has been issued to the transfer company.
Notice
My
is
lords,
in
may kindly come to page number 78, my lords.
Kashinath and
Kashinath and
not
company
there.
not there. My lords.
Amalgamation.
Amalgamation, my lords.
All right, he's seeking.
My lords, I'll not come in the way.
Not today করে দেব। কালকে হবে আবার না কালকে তো হবে না কালকে তো আবার স্পেশালি অ্যাসাইন সোমবার মানডে
Monday, my lords. My lords, deeply apologize.
if the list collapses it will be taken up tomorrow. Yes, Mr. Kundalia was
my lord. He's on legs, my lord, and my lord, I would pray for an adjournment, my lord. We will be seeking some instructions and come prepared, but some time may be given, my lord. May it please, my lord, to keep it in the first week of February.
Sometime means entire month will go.
My lord, because next week, my lord, the 4-day vacation.
You get prepared.
I'll be prepared, my lord, but the specific instructions regarding the virus challenge, because 114.10
Virus challenge, you and Mr. Sharma will not be able to defend.
He is assisting, so
so both of you will not be able to defend the virus.
My lord, because we'll have to take instructions and after that we can supplement it by our
Virus is what instructions? Virus is law.
As my lord, my lord understands.
লিখে দিন।
May I only?
Union of India, the Mr. Bhattacharya will also have to argue this. Virus to Mr. Bhattacharya.
This is regarding, my lord, if subject to correction, this was on the whether the writ petition is maintainable on the point of virus. That is the
No. It's he wants to contend that since it is a works contract.
Yes, my lord.
Where of composite nature, where on what was the term used? Advance. Mobilization advance. On mobilization advance, he is not supposed to pay VAT at the time of taking the advance. He is supposed to pay VAT upon raising of RA bills. As the work proceeds, he raises RA bills and then he is supposed to pay VAT. By the time he raised RA bills, the earlier service tax regime and VAT regime, it went off and it got transformed into the GST regime. The GST regime took over.
Is after the GST VAT, that VAT component is if I'm not mistaken, because there was no exactly any supply of goods.
No, therefore he says that if now it has transformed into GST and there is no provision.
Yes, specifically in 114
providing for this situation.
Yes.
Therefore, will he be discriminated against the others?
Yes, my lord. Regarding that point, we need to get some instructions from.
That was his point.
Yes, my lord.
I'm grateful. Sorry to interrupt. My learned friend is praying for first week of February. Not first week of February, I have some difficulty.
Then you tell me. You suggest
February, and I'll comment to your lordship.
When second week? When 9th?
9th onwards, as it comments to your lordship.
9th, Mr. Bhattacharya.
Yes.
February will come prepared, my lord.
Mr. Rai, learned advocate, appearing for the respondent CGST authorities, submits that he needs some time to get fully prepared in the matter.
The customs.
But last week, your lordship was pleased to hear this matter and this order was passed, Milord. Yes. Milord, over here also the issues are the same.
And you are arguing the same thing.
Same thing, Milord. Just two changes would have to be made, Milord. If I may just, yes. But if I may just indicate, Milord, kindly take the last paragraph of the first page.
Last paragraph
Of the first page, Milord. In that matter, there was an earlier order. In this matter, there is no earlier order. So that reference will have to be omitted, Milord.
Earlier order, last paragraph of the
Milord, first page, last paragraph, Milord. Kindly see the first two lines.
Oh, the earlier order of
yeah.
September 9, this
Yeah.
will not be there.
That will not be there. And Milord, can we come to the second page also, Milord?
Yes.
Milord, the second paragraph will not be. In
You
that
had not
matter-
filed two replies.
No, only one.
Mr. Deb, this can be done with, I'm converting it. I'm appropriately modifying.
Milord, if your lordship would be pleased to have a look at this, Milord, we've made the proposed changes.
I'll do it in. Same order.
I've got that.
Just a minute, there are other matters also. এইটা রয়ে গেছে দাদা।
Lordship, item 5, 6, 8 and 9 arises
6.
8 and 9. Lordship, this is that same impugned order which your Lordship just dealt with in the previous matter. We were also carrying a copy of that Zakir Khan judgment which your Lordship had passed on the 8th of January. And as I,
So Mr. Sengupta's orders can be repeated.
the same order was repeated now, my lords.
Different names.
It was, I can wait for my turns to come, my lords, not a problem. But the order which was passed right now,
5.
is right now can be repeated, my
Very
lords.
well. 5 টা
The corrections are similar. It will not make
5
any
টা
difference.
সেম অর্ডার হবে, শুধু ওই মিস্টার সেনগুপ্তর জায়গায় ওই মিস্টার মুখার্জির নামটা লিখে।
No, Mr. Aniruddha Datta.
Petitioner in item number 5.
You are there.
Yes.
তাহলে ওর
5
নামটা
Aniruddha
লিখে।
Datta করে।
Give your names. And Mr. De for the respondent customs. Give your names. Give your names. So 5 is taken care of.
Lordship, 6 is where let us
5
let
be
it let
over.
it be called.
5 be
Let it
over.
be called.
5 টা সেম অর্ডার হয়ে যাবে তো?
Yes, yes.
ঠিক আছে।
Only one
অ্যাডভোকেটের নাম, একজনের নাম ছিল মিস্টার দে, তা মিস্টার দেই তো। ইউনিয়ন অফ ইন্ডিয়া তো আগেও ছিল,
তারা কিছু
ও তো সবেতেই আছে।
পিটিশনের নামটাও দিয়ে দিচ্ছে দত্ত। Lordship may call on the 6th, Lordship.
Item number 6.
Yes. 6, I am there. Just
6, who is appearing for the respondents? Mr. De, you are not appearing.
Not in 6, not in 6.
6, who is there?
Lordship, appearing for the, okay, last occasion, Lordship,
6 এর একটু দিন।
না, Tirtho Proti Acharya had appeared once for the Union of India. I do not know who was appearing for customs. It's been served. I have the affidavit of service.
Nobody has appeared, Mr. Mukherjee. Nobody has appeared.
Yes, for customs, I see.
You serve a copy. Can you serve a copy on them or what?
It's determined on the department.
Very
I'll
well.
serve one again.
You another
Can I
serve-
hand over this affidavit of service to my
Yes,
lord?
that you hand up.
Hey, affidavit of service. Sir.
Affidavit of service filed in court today is taken.
Seven is there in the middle, not one of us.
Four weeks, that time লিখে নিন, একটা order লিখে নিন। Item 7. An adjournment is prayed for on behalf of the
Eight, nine apart.
On 8, again one of the same.
8, who is appearing for the respondents?
Appearing for the Union of India.
The Union of India
Then
won't.
Lordship, I'll,
Then the same order as 6.
yes, your Lordship, I'll again.
6 er order. Oh, none appears for the respondent. Service, affidavit of service. Same way. Same order as 6.
Yes, your lordship, I'm for the petitioner. Same situation, your lordship.
Union of India. Same order as
I will also
It's
submit the
29 same
affidavit on affidavit. I'll submit the affidavit of
Affidavit of
service.
service will be taken on board.
And your lordship,
Tally
this may be
6, 8 and 9 same order.
your lordship. This may be a bit out of turn, but 651 of 2025 is also same.
Like that. Let it
Very
appear.
well. Then on the next occasion.
My lord, one other thing, my lord, for 5, the service may be taken on record as because they are appearing, my lord.
5 affidavit of service is taken on record বলে লিখে নিন। No, your number is incorrect.
Five.
তাহলে 5 এর affidavit of service টা লিখবেন না। 6 এর affidavit of service টা লিখে নিন নাকি এটা কার? 5 এর ঠিক আছে? ঠিক আছে। দেখে নেবেন যার affidavit of service ঠিক হবে সেখানে থাকবে নালে ওটা ঠিক। আচ্ছা ওই মিস্টার দের ম্যাটারটা উনি বোধহয় ইনস্ট্রাকশন নিয়ে এসেছেন ওটা উইথড্র করবেন করে দিন তাহলে ওটা শেষ হয়ে যায় 1 নম্বর আইটেমটা item number 1 লিখে নিন হ্যাঁ ঠিক আছে কোনো অসুবিধা নেই যে নিক
Hey.
Mr. De, learned advocate appearing for the petitioner. Hand
Your Lordship, in this matter, Your Lordship had granted me liberty to file a supplementary affidavit, Your
They
Lordship.
have filed.
I have already served them on
The
second.
difficulty of my junior is she forgot the brief. I had made we keep tomorrow or any day.
My Lord,
not today. I'm making it not today. It won't be tomorrow. Unlikely. Maybe if the list collapses, because tomorrow those specially assigned matters will gain precedence.
We are there.
Not today, Korera. Just making it not.
Item 11, Mr. Kundalia is appearing in this matter. My lord, I'm praying for an accommodation.
Not today will do.
Not today.
Not today.
I'm for the petitioner. Mr. Banerjee appears on the other side. He's not the-
Bhaskar Prasad Banerjee.
Uh, Not today.
What today? Not today.
Lord, senior mother is not well, praying for not this week.
Who is not well?
Mother, senior's mother, Amit Agrawal.
Not today.
13 and 14.
All right.
Same.
Same.
Much up.
Well, I am for the petitioner.
In this matter, my lord, I sought instruction of the difference, my lord. I'm just praying for some time, my lord. Next
How
week,
much
my
time?
lord. For 7 days, my lord. The
The
instruction has
order
not-
record করুন। Ms. Mukherjee, learned advocate appearing for the respondents.
My lord, in this matter, I am led by Mr. Banerjee. My learned senior friend will continue. I hope it will not be concluded. No, I don't.
But it was taken up on 17th November, so a lot of time has passed.
And today also, because I'll have a
Lordship, Lord.
division bench.
Lordship. But the challenge in this matter is not to an order under section 148 A3 and notice under section 148 which has been issued. But the assessment is 2019-20. One of the I had sold goods to a Delcredier agent. The Delcredier agent is a company by the name of Plastchem Industries, and the customer is Padme Impex Private Limited. So apparently, this Padme Impex had defrauded the banks. The information provided shows that they had taken money ostensibly for buying goods, but the money was diverted. The firm's suppliers did not exist, or things like that. So I was issued a notice under 148A, and the notice really, I'll place that notice. It only sought information from me because they had no material to show that I was in any way complicit or that my supplies were not genuine supplies, because I'm a manufacturer here, not in West Bengal. So they asked for a lot of information, and they said, why should not an adverse inference be drawn? They have not looked at anything, and yet in order to bring it within section 148A, they say why an adverse inference should not be drawn that I am a party to the same transaction as the others. So really that notice was not a show cause notice, could not have been issued under section 148A. Now then I give an answer, and one of the requisition was that I must show genuineness, creditworthiness, and that the transactions are actually the section 68 ingredients. So I provided the answers. There were supplies of the goods, the e-way bills, the packing lists, and the entire money was realized. Since the Delcredier agent was involved, so in my books of account, I showed these transactions in the ledger of the Delcredier agent, because the Delcredier agent had promised to secure the entire payment. So they had in fact even furnished bank guarantee, furnished cash deposit to secure the transaction. So the documents were furnished. Then I went to the officer. The officer said, "You give me documents relating to at least 1 month showing stock movement, that the goods came out of your stock and they were sent. So I gave that the entire documents to show that. Now, in the order which has been passed, the second communication note under which I filed those documents, that there's no reference to that. There's no discussion. And now it is being said, and that was not the show cause notice, that this is an accommodation entry and not money received for supply of goods. Because my answer was that, look, these are goods sold. I have received the money.
This point was not there in the show cause.
But it is not there. That is an accommodation entry. That was not there. And the show cause notice itself, I will place note, it was not, there's nothing there. No answer was required to be given because there's no material at all to show that I am complicit in any matter. Because it simply said I have received so much money from this supplier. But kindly have a look at the notice note which is issued, volume 1, page 43. The first page is that notice itself, and the recording note in Muhammad's submission of this particular allegation, whereas I have information which suggests that income chargeable to tax has escaped assessment within the meaning of section 147 of the Act on account of the following. Information in accordance with the risk management strategy formulated in this regard. So this suggestion that there is information which suggests income chargeable to tax has escaped assessment, that is not borne out from the alleged information which is there. That is at the next page. Information was received from Central Economic Intelligence Bureau, New Delhi, by letter dated 7th May 2021 regarding information shared by the Bank of Baroda with regard to siphoning off the fund by Padme Impex Private Limited. The relevant portion of the information in this case is as under. But I will not trouble my lord with the what is set out there. Then at page 45, paragraph 2. As per information received, Padme Impex has siphoned off funds from CC account by using fake invoices, lorry receipt, and using several current accounts with SBI, ICICI, BOB, etc. Further, for the period from 1st April 2018 to June 30, 2018, the company remitted rupees 20.43 crores by debiting the CC account to their associate firm, Polyplast and Paper Products, rupees 4.13 crore to Montex Packaging. The company has dealt with Mrs. Polyplast and Paper Products, Mrs. Montex Packaging, Mrs. Gala Polyimpex, which are neither in supplier nor creditors list, and siphoned off the funds through these entities. Further, total LC amounting to rupees 9 crore were opened during the period 20th March 2018 to 27 March 2018 in favor of single supplier named Mrs. Apple Impex. All LCs were devolved and payment has been made after debiting the CC account between 12th June 2018 to 25th June 2018, which is still not adjusted. On investigation by bank, it was found that the address provided in the invoice bill was fake and no such firm existed at the address. Further, as per original proposal, the company is engaged in manufacturing plastic products, but on investigation by bank, it was found that the company was purely a trading firm engaged in trading of plastic granules. 80 to 90% of the firm are trading sales. From the above analysis, it is seen that letters of credit were issued in favor of Mrs. Galaxy Polyimpex on earlier dates during financial year 2017-18, but on later dates during financial year 18-19 in favor of Mrs. Apple Impex. The proprietor of both the firms are same. It is also seen that stock statements in respect of the same were not submitted, which creates suspicion as regards the nature of transactions carried out with these entities. Then, on perusal of the information available on Insight portal, it is observed that last ITR was filed by the company for financial year 2017-18. The assessee has not filed return of income for financial year 17-18 relevant to assessment at 18-19. Therefore, it is evident that the assessee has not offered any income for taxation from financial year 18-19 to till date. But they're talking about that Padme Impex. Screenshot, and then at page 47, bottom is the summary of what is said earlier. Based on the information shared by Bank of Baroda, Mrs. Padme Impex has engaged in fraudulent activities by siphoning of funds from the CC account through the use of fake invoices and lorry receipts, along with transactions involving non-existent.
And you have not filed income tax return?
No, that is
after-
that Padme Impex, no, not me.
Oh,
They are referring to Padme
but
Impex.
they say the SSE has not filed?
No, my return is there. No, this year it's there. It's not, I'm not a non-filer. No,
But they use the expression SSE. It
Yes.
shouldn't have been then.
not yes, no, they have actually.
As
no,
if you have not filed.
That is not the case. No, that is not the. No, they have processed my return for this year. No, our assessment is
I
1920.
would have thought of Padme if SSE, expression SSE will definitely mean the person addressed to as the, with the notice.
Lordship, no, that is copy pasting. No. They, because in that process that they have referred to that particular assessee, but no, it is not not in my case. Kindly similar that the top at page 46 there in the screenshot, there is a name mentioned at the top. No. Profile view for Padme Impex.
Yes.
So no, it is it cannot possibly refer to me. But they're referring to this non-filing by this Padme Impex. And then look at page 47. That will also become clear from page 47.
This is page 46 onwards. They begin with SSE.
Yes.
So they mean Padme Impact since the inquiry is in respect of that SSE.
Lordship.
That is how we'll have to.
Yes, ma'am. Because in page 47, last paragraph, going on to page 48, no, there they can you see this is the summary? No? Based on the information shared by Bank of Baroda, Padme Impex says.
Yes, Mr. Banerjee, then how do you correlate? Because they have not filed returns. How does Haldia Petrochemicals Limited become a related party to it in the sense that their income has escaped assessment?
Lordship is.
How do you correlate? Because there has to be a direct link or an.
He has become the beneficiary.
Where is that? Where is that finding? There's nothing. There is precious little on record to even arrive at that conclusion. It says the SSE has not filed return. All your arrows are directed to Padme Impex. Then you suddenly turn the vote to him and kill him. This.
Then we usually what we do, Lordship knows better than us. When someone takes a advantage from someone's fight.
No, but where is that conclusion? You show me that conclusion, how he has taken advantage. I don't, you say that he has transacted with him. Merely having transactions won't impugn the transactions. The transactions won't be challengeable merely because of them being conducted. There has to be something worth impugning the transactions. How have you challenged the transactions? How are the transactions suspicious? That has to be brought on record, at least at this stage. I don't say that you have to come to a firm conclusion that it has been done. But any evidence having enough credibility for one to assume also should be there. Because the word is suggest. Yes. Something that suggests that income has escaped assessment. Now that suggestion worth the name, at least on. In this, I have not been able to find out. If you can indicate something more, it's definitely going to.
That's completed. I will take.
No, on this only you satisfy because up till this, I am not satisfied that there is material enough to suggest escapement of income. I mean, income having escaped assessment.
Let him make his point, Lordship. I'm taking note of it. I will.
This is the point precisely.
And look, what he has done, look, in the order which has been passed, look, he is trying to, and not that look, what I furnishes any basis to, but not he's criticized that in a particular way to create a cloud. And I'll show that there's no reason for that cloud at all. But the records ex facie show that he is misreading or omitting to consider certain things. Once we look at it, there will be no doubt at all. He is not. I'll explain what happened. There are in almost 46 invoices, and the goods have gone over 17 days. No, over 25 days. Not on 17 days there are single invoices. On 8 days there are multiple invoices. The reason for multiple invoices, not either the entire quantity could not be loaded on one truck, therefore there had to be separate invoice, or not the goods were from different batches. So for every batch there is a separate invoice. So there are 46 invoices, 25 days. Now he's muddled that up to show as if there is a mismatch, whereas not there is no mismatch. It's especially apparent from what was submitted before. So he is trying to find fault with what was given, but even that does not suggest escapement of income. Even if we go with what he has said, because he had nothing. He had nothing at the beginning. He had nothing at the end.
And where is the 14883 order?
No,
Because
that
this
order
the
is
notice.
in volume 5, page 686. But he deals with at page 694 the discussion, and from page 695 up to page 700 deals with the aspect of whether the notice could have been issued by the jurisdictional officer and not the faceless. And then page 700 onwards is where he's touching upon the other points.
Oh, they've gone on that creditworthiness and all. You have not been able to.
And also know that answer is there. The reply is annexed. And he has himself listed my response. If my lord is pleased to see at page 695, the documents which I had given.
5.6.4, they say that the company was specifically requested to produce relevant documents to establish identity, creditworthiness. No write-up on this request has been found in response of the SSC company. No documents to this effect were found.
Factually incorrect. Factually incorrect. There is a the documents run into some 500 odd pages, and there is an answer given as to why it's genuine and creditworthy, and so it is not that there was no answer. He is in fact himself reproduced a list of some of the documents at page 695 in the same order. But how he disregards them is
we'll have it on
as a continuing matter whenever. So if tomorrow if this gets called, I'll be there. Otherwise, the Monday.
Yes, only if the list collapses, it may get called.
If the assigned matters are not taken up, then
because we'll have specially assigned matters at the top.
But
otherwise, Lordship, what will happen, since it is a continuing matter, we have to be panic state of mind that when there is a polling, we might not go.
Very well. You tell me a date whenever it's convenient.
But Wednesday, Thursday, I'm not. Let it be tomorrow. What is the problem? Can we have it on Monday then? My learned friend has difficulty for
Monday.
But as a continuing matter.
Yes. Monday আর কিছু আমাদের fix নেই তো?
And we can keep a time also.
No, it can be continuing matter first.
ওদের পরে দিয়ে দেবে কালকে কন্টিনিউইং ম্যাটার আজকে ঠিক আছে There'll be a few small applications above this and then it will come
On Monday.
Monday. Heard Mr. Ketan, learned senior advocate appearing for the petitioner, and Mr. Banerjee, learned advocate appearing for the respondent revenue authorities, assisted by Mr. Sharma. Full stop. List this matter for further consideration on January 19, 2026. It will appear immediately after a few matters. I'll have to rise because of a division bench.
Yes.
Thank you.
প্রবলেম আছে
আমারটা কন্টিনিউ করলে না বলেছিলাম